Assalamu alaikum friends, you are watching Tax Dosti videos and we are discussing a very important question on every Pakistani taxpayer's mind. Do I have to pay taxes if I'm a resident on my assets? Because as far as income tax is concerned, income tax is a tax on income, not on assets. So 208 petitioners filed this case in Sindh High Court, and we are covering every paragraph. This is paragraph number 11. We are in part 11, and the judge is writing that whether this section 7E, tax on deemed income, is confiscatory nature or not. Confiscatory means when you pay more than what is due of you. The honorable judge writes, it has been vehemently argued on behalf of the petitioners that the levy in question is confiscatory in nature inasmuch as the properties in question are idle and not generating any income. Therefore, there may be a case that a taxpayer does not have any money to pay any such tax, or it does not have any further source of income. This group of people, this subgroup of people, especially includes pensioners, people who have saved money and invested in property and have very little income per se. But this argument can be countered by that such people have other sources which they do not declare, or they may have actually rental income or capital gains which they are not disclosing, but is merely holding such property as asset or which have devolved upon and owned as legal heirs. This is possible that you are a young chap studying in university and you get a lot of property from your parents' inheritance, and in tax year 2022 you are saddled with a lot of tax just because you're holding property valued more than 25 million. So there can be cases, and as I've suggested in many videos, that on individual basis, in violation of fundamental rights, we can raise the question, but this judgment seems to answer all those questions. We proceed by saying, however, again, there is no concept on of invalidating a levy or tax merely on this ground that the taxpayer does not have any such capacity to pay the tax. Now, this is a questionable statement. According to Article 3 of the Constitution, Article 3 says that everyone, according to his need, and to take from everyone according to his ability. So, maybe Article 3 would have been pressed here and given. जी सर, सर जी वीडियो बना रहा हूँ, इसमें आपकी आवाज़ भी अब आ रही है, आप बताएं. अच्छा, एक 10 मिनट लगे. चले चलते सर, मैं बस आ रहा हूँ, सी यू फिर. ठीक है, मैं पूछ लेता हूँ सर. ठीक है सर, थैंक यू सर. Much stress was laid on the case of Pakistan State Oil, where in its peculiar facts and circumstances, the Honorable Supreme Court had provided an exception to levy tax on Pakistan State Oil, who was not generating any income to the extent which could sustain the levy of presumptive tax on dividend. Firstly, it may be of relevance to observe that the facts as discussed in Pakistan State Oil were materially different and not available to the present petitioner. Secondly, with utmost respect and humility at our command, we may observe that the case of Pakistan State Oil was decided by a three-member bench of the Honorable Supreme Court, whereas Honorable Supreme Court in Ilahi Cotton case, supra decided by a five-member bench, has been pleased to hold the levy of tax in its operation may result in hardship or advantages or disadvantages to individual assessees which are accidental and inevitable. Simplification, this fact will not constitute violation of any of the fundamental rights. It has been meaning that the judge has dismissed the case against fundamental rights. Let's see if this point goes in front of Supreme Court and Supreme Court reconsiders Ilahi Cotton case in light with all these petitions, and let's see what the present Supreme Court decides. It has been further held that the taxing power is unlimited as long as it does not amount to confiscation. That means the state has the power, unlimited powers to tax. Similarly, a levy or imposition of tax cannot be struck down merely because of the reason that a taxpayer does not have the capacity or the amount of income on which a tax has been levied. Hence, it may be rightly remarked the Act obliges every person who holds land to pay the tax at flat rate prescribed, whether or not he makes any income out of the property or whether or not the property is capable of yielding any income. Reference to footnote number 16. 16, in this case, AIR, All India Reporter, 1961, Supreme Court, page number 552. Acha. If they cannot afford the tax, the property is liable to be sold in due process of law for realization of public demand. It is but natural that while paying taxes, there is always an element of hardship for a taxpayer in discharging his or her liability so created by the taxing statute, but this is inevitable in every taxation law, and this within itself is no ground to struck down a taxing law. So the judge is convinced that this law is not confiscatory, it's not violating any person's fundamental rights. And then again, I'll say that for arguing this case, it would have been better if the advocates would have argued Article 3 of the Constitution of Pakistan. The quantum of tax levied by taxing statutes, the conditions subject to which it is levied, the manner in which is sought to be recovered are all matters within the competence of the legislature, and in dealing with the contention raised by citizens that taxing statute contravenes any article of the Constitution, courts would naturally be circumspect and cautious. Again, the Lahi Court and the Honorable Supreme Court has dealt with the argument also raised therein on behalf of petitioners that the impugned levy is confiscatory in nature, as it is demanding tax beyond the capacity of taxpayer, in as much as there is no corresponding income of the taxpayer to pay such a tax. To be fair to the present judgment, the present honorable judges are referring again back again and again to Ilahi Cotton case, and if that case was argued properly, maybe these doubts wouldn't have arisen then, but for the time being, the judge is relying on Ilahi Cotton case, Ilahi Cotton Mills case 1997, which authorized these sections 80C, 80CC and 80D to be part of then the Income Tax Ordinance 1979. Over there, the argument was losses were being suffered continuously by various taxpayers, whereas the levy of presumptive tax or minimum tax under Section 80C, 80CC or 80D, 80D has now become Section 113 of Income Tax Ordinance 2001. It was previously 80D of the Income Tax Ordinance 1979, and 80D was held to be valid law in the Ilahi Cotton case. Similarly, 80C and 80CC too was confiscatory, and it was observed by the Honorable Supreme Court that since there is a presumption in favor of legislative competence as held in a number of judgments referred to herein above, the burden to show that the imputed taxes are confiscatory or expropriatory was on the appellant. In our view, they have failed to bring on record any reliable material on the basis of which can be concluded that the same are confiscatory or expropriatory. It was further held that the question as to whether a particular tax is confiscatory is to be determined with reference to actual earnings or earning capacity of an average prudent successful entrepreneur in particular trade or business. The fact that the particular assessee has suffered losses during certain assessment years is not germane to the above question. Therefore, in our consideration, the present levy cannot be declared as alta vires to the Constitution, mainly on the ground that it is confiscatory in nature. So, in this last paragraph, the judge has reproduced the judgment and the logic of Ilahi Cotton, and basically he has dismissed the idea that it is a burden that is too much for taxpayer. Now, in legislative competence, that is paragraph 12, we will discuss in part 12 why the judge thinks that the federal government had the power to impose tax under section 7E. See you in the next part. You are watching part 11.